Welcome to today's webinar, How Small Businesses Should Prepare for Stricter Immigration Enforcement, brought to you by the NFIB Small Business Legal Center. To our current NFIB members, thank you so much for being an active participant in the small business conversation and for your continued support. To those who are not yet members, welcome, and consider joining the nearly 300,000 small business owners who are fighting for small business with NFIB. Our success is based on strength in numbers. Each new NFIB member makes our voice a little louder and strengthens our efforts to fight anti-small business legislation. If you are or know a small business owner who needs their voice to be heard, visit NFIB.com or call 1-800-NFIB now. And before I introduce our presenter today, keep a few things in mind. If you have any issues with audio, please ensure your computer speakers are set up properly and know that your internet connection does affect the clarity of sound. We are recording today's presentation, and after each webinar, all registrants will receive an email with the link to the recorded webinar and link to download the slides. We encourage you to enter questions in the Q&A box on the right of your screen. Just click Ask a Question and type your inquiry. We will address questions at the end of the program. We typically get a lot of questions during these webinars, so if we don't get to your particular question, we hope we will answer one that will be helpful to you. And now I'd like to introduce our presenter today. Laura Foot-Rife is a shareholder at Greenberg Traurig and has more than 35 years of experience representing businesses and organizations in the business immigration and compliance field. She is also a business immigration advocate and has long chaired prominent business immigration coalitions that helped shepherd through business immigration reform legislation during the Bush and Obama administration. We also have Elizabeth Melito, Executive Director of the Small Business Legal Center here with us today. But now I'll hand things over to Laura. Thank you so much for joining us.
Thank you so much, Casey, and it's really an honor to be here with you and Elizabeth and Scott Fegley. This is a very hot topic now. It is something that we've been talking about a lot now that the Trump second administration is in office, and we just hit the 100-day mark. So we're going to start with just a little overview. As Casey mentioned, I've been working in immigration policy and business immigration for more than 35 years. I've led several business coalitions, and I currently chair the U.S. Chamber of Commerce's Immigration Subcommittee. So we've been working with all kinds of administrations on business immigration reform and things that are important to businesses, small and large alike. So I hope I can answer your questions, but I want to give you a little overview. Since the Trump administration has come in, they are fulfilling some of their promises with executive orders that do impact businesses. So just wanted to make you aware of some of the national security and kind of Buy American, Hire American executive orders. There has definitely been increased scrutiny of petitions that have been filed for visas. There obviously been increased vetting of foreign nationals that are in our country. There have been some delays in visa issuance as staff is turned over at the different agencies. And there have been additional vetting mechanisms that have been put in place. At the first Trump administration, there was a heavy emphasis on buying American and hiring American workers, and that has been reintroduced in Trump Point 2. As we all know, hiring American workers or U.S. workers is something we all want to do. Sometimes we need to hire foreign workers, but that is an emphasis of this administration. This administration has been expediting the removal of individuals in the United States. They have been revoking certain programs that were introduced during previous administrations. Some of these are temporary protected status programs. Some of them are humanitarian parole programs. Some of them are asylum programs that were instituted. Those are being rolled back. Some of them are being challenged, but there are a significant number of people in the U.S. workforce now that had those types of statuses, somewhere between 6 and 9 million people who are kind of under threat of losing that status, and that can impact our businesses, because some of them are lawfully authorized to work right now, but may not be in the future. So that destabilizing of the workforce is something that we need to be concerned about, because we want to keep a workforce that we need, but we also want to make sure we're compliant with immigration laws. So some of the general impacts of these executive orders and actions early on in the Trump administration are increased immigration raids and audits. And we're going to talk about I-9 compliance and what's happening there. Again, impact on these humanitarian programs, people who have applied for political asylum, people who are Ukrainians who are here for you, people who are in the process of getting political asylum from Afghanistan, the Cuba, Haiti, Nicaragua, Venezuela humanitarian parole program. A lot of these programs are in the crosshairs now and will result in people being ineligible to work in the United States ultimately. We do expect some global impact on, kind of foreign national travel. You're already seeing people who may be in your workforce ask you whether it makes sense for them to leave the country. Sometimes that answer is no, if they fear that they're going to have trouble getting back in. We are already seeing some of our members, especially of the Essential Worker Immigration Coalition's membership, we've been experiencing workforce shortages in nursing homes and in the construction industry, but those shortages are already starting to be felt more acutely. So it's important to try to be compliant, stay on top of what's going on with the current administration. If you do have sponsored employees, people that you have sponsored as an employer, you should look at filing their extensions with Homeland Security early. You should anticipate, if they do travel, that there are going to be some delays in getting visas issued. Those foreign students that are on your payroll, they need to be working closely with their foreign student advisors to make sure that they're still eligible for work authorization and you're still eligible to hire them. So I think now, even more so than the first Trump administration, we need to be on top of our immigration portfolio and those people that are sponsored or are on some kind of work visa or some kind of employment authorization document. So that gets us to kind of the core of the presentation. And the responsibility for employers to fill out and complete an I-9 form for each employee that was hired after November 1986 has been around since November of 1986. That has the Immigration Reform and Control Act put that burden on employers. And that's all of our employers. We all have to do a check to make sure that people have sufficient identity and employment authorization document. Many people just ignored that. And I would say, if you feel like you're too small to do it, I think you need to either review these slides again or go on the USCIS ICE website and get yourself familiar with the I-9 form, because it's really important to protect yourself and have I-9s for everybody that is in your workforce. Worksite enforcement audits of employers are carried out by Immigration Customs Enforcement, and you've probably heard a lot about ICE. Immigration Customs Enforcement, they have a lot of duties. They are going after individuals who have overstayed orders of deportation. They're currently going after individuals who have already been removed and then come back in. They're also targeting people who are here, have committed crimes. But one of their other duties is to go into workplaces and review the I-9 forms. So ICE comes in and looks at your employment verification records. They try to determine whether you've adequately screened your employees or your potential employees. Have you gotten that appropriate identity document? Have you gotten that appropriate work authorization document? And if that appropriate work authorization document is time sensitive in that it expires at a certain time, are you tickling yourself to go back in to double check and re-verify those documents? So ICE has the right to come in and look at your documents. And then we'll talk about the difference between an audit and a raid. But it is really important for the employer within 3 days of hiring somebody to look at the back of the I-9 form, check the identity documents, check the work documents that they're presenting, and make sure it's compliant with those documents that are listed on the back of the I-9 form. So there's a lot in the media about ICE going into different businesses, and is this a raid, or is this an audit, or is this just ICE having a friendly visit? It's really important, more so to be good citizens of the United States, but also protect your business and protect your lawful workers, to have a protocol. And how do you actually deal with ICE worksite visits? That should be written out. And I know a lot of you don't have your own HR folks, but it's not that difficult to have a process so people aren't surprised when ICE comes knocking. So create and memorialize a uniform process for responding to worksite visit. Is this a notice of intent of inspection? Are they coming with a subpoena? Do they not have any of that? Train either yourself or your receptionist on how to kind of decide what kind of visit this is. Ensure that you have somebody on call. If you have, the owner of business needs to be called and they can call their own immigration counsel, that's important, because sometimes ICE is on a fishing mission and it's not an official visit, and you really don't need to turn over documents. So having a protocol, it can be just bullet points. And frankly, I can share some protocol materials with Elizabeth after this. I know she's sharing the slideshow. So if ICE comes and has what's called a notice of inspection, that does not mean that you need to turn over documents right away. And presumably you all have your I-9 forms in order. If you don't, you need to get them. But you are required to have your I-9 forms on site. And if ICE were to come, you don't need to voluntarily turn over the documents if they have a notice of inspection. So by regulation, if they have a notice of inspection, you have 3 business days to confer with counsel and pull the materials together, get it organized to make sure you're not turning over documents that aren't necessary. You wouldn't turn over wage and hour documents. You wouldn't turn over other personnel records. It would just be the I-9 record. Even if I-9 records appear to be in order, you would not turn them over on that day. It's really important to remember that if ICE comes in and you have somebody at the front desk and they turn over documents that day, you may not get them back. So if it's a administrative notice of inspection, you have 3 days. You need to be very polite and say, listen, we have a protocol, and we're going to be talking to our counsel, and we're happy to respond on the day that we negotiate that we turn over the documents. Usually counsel can negotiate up to 2 to 3 weeks, depending on the size of the business. And the ICE agents are very busy, so they may not actually have time to review them in the 3-day period. So again, it's really important for people to figure out who is at the door. Is it an ICE agent? Is it a local police officer? Get a copy of their badge, let them know that you have a protocol, and see what document that authorizes their visit that day. Just coming in and asking for documents is not enough to trigger the notice of inspection. They need to have an official notice of inspection. So if they do have a notice of inspection or a subpoena, and we'll show you copies of each one of those documents, then they may push you to try to get copies of the documents immediately. Again, you want a copy of the person's badge, you want a copy of their card, and you want to see the authorizing document. If they have a notice of inspection, it will say, and I'll show you in a minute, it will say the name of the business. Make sure that they're at the right place. You may be ABC company, but that notice of inspection may say XYZ company. And that's an easy way to basically say you're at the wrong place. You shouldn't be here, and this doesn't pertain to our business. So the notice of inspection has to relate to you. It may list some people that they're interested in speaking to. You should see if those people relate to the people that you are employing. If it doesn't, again, it's not an official visit to your business, and you can say you've got the wrong place. So that's why it's really important to make sure that people are aware, your owner is aware, or somebody who deals with your HR is aware that you do have the right to be cordial and nice, but push back if they don't have the right documents. If there is a notice of inspection and the individual, the ICE agent, pushes to speak to people or to actually get copies of documents that day, you should call the owner of the business or the HR person or your in-house counsel or your out-house counsel, because many times I've been able to get on the phone with the ICE agent and work it out. You can say, listen, we'll talk to the regional office to make sure that this is an official visit. We think you may be mistaken if the notice of inspection is not related to your business. So many times you can diffuse the situation by calling counsel and letting them know that there is a protocol in place, and we can, if the notice of inspection does relate to your business, negotiate a time that works for both parties to actually turn over the documents. There is a difference between an ICE audit of your I-9 forms and a raid. And we've heard about the point one first go round raids. I think there was a poultry processing plant that got a lot of media attention. That was an actual raid of a site. A raid is usually a joint enforcement effort. ICE will be there, but also maybe some other law enforcement. And in order to come on the property, they need to have a warrant that is signed by a judge. It's not a notice of inspection that's an agency administrative document. It is actually a warrant that's signed by a judge. If there is a warrant, ICE can only go to the places described in the warrant. So again, you have the same kind of interaction when you have a raid. Can I see your badge? May I see your card? We have a protocol for ICE visits to our office. We need to talk to our owner. We need to talk to our counsel. And can I see the authorizing document? So you want to see the warrant. If it's signed by a judge, you want to read the warrant. And of course, snap pictures of with your phone to make sure that your attorney and or your owner has pictures of the warrant. Look at that warrant and see if it describes your company. Is it describing a vendor? Is it describing a staffing company that you're using? And we'll go into what happens with staffing companies a little later. But they can only go to places described in the warrant. So if the warrant's for XYZ company and you are ABC company, that warrant is not for you. And we don't want them coming into the place of work unless the warrant specifically describes the business and the people they're looking for. So if they come, again, ask for their identification, take a copy of the badge and the professional card, make a copy, snap a picture with your phone. Everybody has phones now of the authorizing document. Make sure it gets to the people who know what they're doing. And read the document, make sure it's an official visit. Let them know you're represented by counsel. If there's a search warrant signed by a judge, they can only look at the places that are identified in the warrant. If it is an accurate identification, it is your company and they're looking for a person, it will say in that document, and that person doesn't work for you anymore, or you don't recognize that name, that person never worked for you, again, and try to diffuse the situation and say, listen, having you come on premises, even though we understand you have a warrant, we do not recognize that person's name. That person doesn't work here anymore. And a lot of times that will diffuse the situation. Many of our businesses, there are in construction, there are OSHA sites, there are OSHA issues, there are health and safety issues, and we don't want ICE coming into situations which could result in violations of other federal laws too. So it's really important to try to diffuse the situation if you can. Again, types of inquiries. There's a regulatory inquiry, which is a notice of inspection. And again, they don't need probable cause to issue this, but it will give us by law 3 days at a minimum. That's an administrative document. Subpoenas, court or other subpoenas are court or other administrative orders that are seeking documents. A search warrant is issued by a judge and is issued because there's probable cause for them to believe that you have something on your premises that they need, most likely people, but also it could be documents they believe that are suspect. During a search, if there is a warrant, don't consent to search on behalf of the company. You need to have somebody else, your owner or your attorney, consent to a search. Again, we're only, if it's a warrant, we're only allowing them to look at things that are identified in the warrant, not all of our files, not all of our people. Don't destroy documents. Many times the ICE agents are coming by without any official business. They don't have a warrant. They don't even have an administrative notice of inspection. They are just trolling for information. None of your people are required or obligated to speak with agents. You can't instruct them not to, but many times we'll see ICE just sitting in the parking lot waiting to speak to people as they come out of the job, or they may be pretty bold and go up to the front desk and say, I'd like to speak to some of your employees. And the appropriate response is, do you have an official visit or here? Because having you speak to our employees without an official reason for being here is disruptive of our workforce. So we'd be happy to have you talk to our owner or our counsel or HR, whichever protocol you have. So if they do come in with a warrant and take your files, you're going to want to debrief everybody afterwards, and there'll probably be some damage control that you need to do with your current employees on reassuring them that you do have a protocol for dealing with this and you are working with the authorities to make sure that everything is in order. So this is what a sample warrant looks like. You can see it's been signed by a United States magistrate. And you can see the order. This is coming out of a Minnesota court. And it's for the Swift company. Just flipping through here. This is what Immigration Customs Enforcement issues when they are coming to look at your I-9s. It's just a notice of inspection. Sometimes they'll email it. Sometimes they will hand carry it. Sometimes they will mail it. Many times these days, they are printing it out and bringing it to you. They're bringing this to you. And this is the one where you have the right to push back for 3 days at a minimum. If you get your counsel on the phone, you can probably negotiate out more days, but this is the one where you would not just turn over documents. You would say, I understand that you are Agent Smith. I've got a copy of your badge, your card. We have a protocol here, and we will be back in touch with you. So that's your notice of inspection. Another sample notice of inspection. And you'll have those in the packet that's been distributed. These are just some resources that they allow you to see. Some people use E-Verify. You can see E-Verify. The E-Verify program is used when you hire people. You see their document of identity and whatever they've chosen to show you is their work authorized document. And if you enroll in E-Verify, then you can actually go into the online system and get an E-Verify verification, which you put attached to your I-9, and it shows that the U.S. government has evidence that this person is work authorized. Many smaller businesses don't use E-Verify, but we do expect that E-Verify will be made nationally required. And many businesses will sign up for E-Verify just to give themselves some extra kind of protection if there is an audit. If you use E-Verify, that's kind of a nice tool to show Homeland Security. We have an I-9 protocol, we re-verify, and we use the E-Verify system. So we talked a little bit about vendors and your subcontractors. A lot of times we are finding that companies are not necessarily the target, but their staffing company or their vendors are the target of the particular ICE visit, whether it's an audit or whether it's a warrant. So before you even engage vendors, it's really important for a company to have language that specifically puts the onus on the vendor to comply with Immigration Reform and Control Act. You, as the prime contractor or the owner of the business, doesn't want to subcontract with vendors who you know are violating immigration laws. First of all, you'd be held to stand in the shoes of your vendor. But you want to be at an arm's length too. You don't want to see their I-9 forms. You want to put the onus on them in writing to say, you must adhere to labor and employment laws and immigration laws, and that's on you. So if ICE were to come to your office and have a notice of inspection, let's use that as a hypothetical. If they have a notice of inspection for your vendor's I-9s, you immediately should say, of course, we have a protocol for dealing with I-9s here, but I can see you're looking at ABC Staffing Company. They're our vendor. We do not control their I-9s. Their office is down the street. And you could still call counsel. They'll talk to counsel about what's just happened. And then I would have counsel call the vendor and let them know that there's a notice of inspection coming for the vendor. You do not want to stand in the shoes of your vendors. But even more importantly, you do not want to keep as your vendor somebody you know who's violating immigration laws. I had a client just recently who's working with a staffing company, and the staffing company miraculously has hundreds of people that they're able to bring in. And the general manager of the company said, yeah, they have great people. They come in every week through Mexico. We kind of stepped back and we said, how is this vendor relationship established? Do you have the appropriate language? And when we can talk to the staffing agency, the vendor, they admitted that their people were not I-9'd. At that point, you need to really separate yourself from that vendor, because you could be held to stand in their shoes if you know they're not complying with immigration laws. So it's important, especially in this environment, to make sure when ICE comes to you that you say, we have protocols for our vendors. this ICE official visit, whether it's a raid or audit, is not for us. And the vendor is down the street. And then to give the vendor a heads up that ICE has come by and was looking for them. But that's gonna open up a conversation for many of your contracts or your subcontractors, your vendors. You really do want to make sure you have solid language in there that makes you have an arm's length transaction from them. I know I covered a lot in 30 minutes. So I'm going to stop there and see if Elizabeth wants to start with the questions.
Sure. So thank you so much, Laura. Let's see. We've got, and you can please continue to type your questions in the chat box too. But I'm going to start with those who submitted a question in advance, and thank you for those that have done that. So the question is about updating the Form I-9s, and when is that to be done? Do I need to do it if I have had employees for a very long time, say 10 plus years? Mm-hmm. Or is it just if a document has expired? What are your recommendations, or what is legally required?
That's a really good question. I think right off the bat, you need to know that you are not held to the standard of being a document expert. You're not the document police. You are a reasonable person. So if a reasonable person would take a driver's license and a social security card or whatever the individual has presented, which are on the list on the I-9, you should be protected. The company should be protected. Now, if you have done that and the individual appears not to have a document that expires, so their work authorization document doesn't expire, they don't have an employment authorization document that says expires in May of 2025, you do not need to go back to those records again. You do not, even if it's an old Form I-9 and they've gone through several iterations, you do not have to go back and ask for current documents. That being said, if you are doing an audit of your I-9s and you notice that things weren't done properly, maybe only column B was filled out when you should have an identity document and a work authorization document. At that point, you may say, I have a deficient I-9. Only if it's deficient or if it needs to be re-verified that you need to go back and ask for new documents. But if it's not deficient, you've got a U.S. worker, then you don't have to update those I-9s.
Okay, great. Thank you. Quite a few I-9 questions here, so we'll stick with the I-9s first. Okay. This is from Darlene. Our I-9s are in our home office where all the employee records are kept. This is not the business location. And that probably is not uncommon with small businesses.
Mm-hmm. And that's perfectly acceptable. Some businesses decide to keep all the I-9s in one central place, and they may have several different branches, and that's fine. And that's another reason why when there's a notice of inspection, there's time to get those I-9s through by regulation. So if somebody comes to one of your branches and says, hey, listen, I want your I-9s now, and just has a notice of inspection, you can legitimately say they're kept at our corporate headquarters. We will be getting back in touch with you, and once we negotiate a time to deliver the I-9s, I'm sure corporate headquarters will package them and we'll have our counsel contact you. So that's fine to keep them at a corporate central location.
Great. Question as to how far back are they typically looking at I-9s when they come in for an audit or a raid?
So that brings up another point that I should bring up, but usually it's 5 years. It's a 5-year look back. So they'll want to see a payroll run of everybody who's still employed with you or has been employed with you over the last 5 years. I-9s can be destroyed after a certain period of time. So if you have I-9s that go back to 1986 and people aren't still with you, you should go through that analysis of when can we destroy them, because you just don't want to keep I-9s that could have been done maybe incorrectly or just didn't have the right signatures on them, or they weren't done at the right time, that could cause they could cause a violation or a fine. If you're able to get rid of them, you should get rid of them. But generally speaking, it's a 5-year look back for I-9s.
Do copies of the IDs need to be with the Form I-9?
And that is a really good question. If you use E-Verify, you must keep certain copies of the documents. If you can choose whether to keep copies of the documents presented or not. And whichever one you choose, you need to be consistent. You don't want to be discriminatory. My advice is generally to keep photocopies of the documents. Remember, I said you're not the document police. If it looks like a reasonable person would accept that green card or accept that driver's license and social security card, keep those documents, because then it's further evidence. It will help mitigate any kind of damages that you might be assessed, or fines or penalties, if you have copies of those documents. If you don't, and they find that the individual has fraudulent documents, you may not have known that, but if you find out they do, they could charge you with a substantive violation. So I would say keep documents if you can.
Okay. And do we need to update I-9s when a driver's license has expired, if the driver's license was used as one of the documents for the Form I-9?
No, you do not. So we all have driver's licenses that expire. Usually it's to update the picture, or, whether you need glasses or whether you can drive. So you don't have to update when an identity document expires. It's the evidence of work authorization. If that expires, like an employment authorization document, it says EAD across the top and it looks like a driver's license. Or if the person has a visa, an H-1B visa, and their I-94, their entry record is expiring, that needs to be updated, but not the document of identity.
Okay, thank you, Laura. Temporary protected status question, TPS. With the moving expiration date, what date are we supposed to follow as the employer?
This is where it gets really complicated for employers. It's super complicated.
This is not a simple answer. I understand.
It is tough because there's so many different countries that currently have TPS, and all of the dates change. And I don't know if you all are familiar with the Federal Register, but Homeland Security puts out statements, official statements on TPS in what's called the Federal Register. It's online, and they have put out statements trying to end TPS that were started by other administrations. They have put out just recently, they extended TPS for South Sudanese for another 6 months because it was expiring this week. So it's complicated because your people may have an employment authorization document that's coded as TPS, and it may be expired, but that Federal Register notice that was published by Homeland Security may have extended that employment authorization document for another 12 to 18 months. So it gets pretty complicated. And what generally happens is you should look at your employment authorization documents, the EADs, and those can be used for TPS, for humanitarian parole. If it's expiring, ask the individual to provide evidence that they have, you're basically re-verifying their employment authorization, and they may bring back to you the Federal Register notice that says, TPS for El Salvador was extended for 18 months, and this is evidence of the auto extension of the EAD. So it really depends on the country. It depends on the courts now, because the Trump administration tried to end Venezuelan TPS, but the courts didn't let them. So even though the Trump administration said they were going to, the court said they couldn't. So there is ongoing TPS for Venezuela. So I think, to keep it simple, pull up expiring employment authorization documents and ask the individual to provide you with evidence. And if you can't figure, between the two of you, you can't figure out whether there's an extension, call your counsel, because we can do it. But again, it would be under TPS in the Federal Register notice, and it's also published on the USCIS website. But it's a complicated one, and this administration is trying to end a lot of TPS programs.
Okay, moving on to ICE agents. When they come on the premises, do they have access to the employees' cars, which are parked in our company parking lot? If you
So
know.
If ICE comes on with administrative notice, they have no access to cars. If ICE comes onto your premises with a warrant, the car would have to be listed in that warrant. If the employee is listed on that warrant and the employee voluntarily gives access to their car, then they'd have access to the car, but generally no, not unless it's identified in the warrant.
Okay. Can a bookkeeping, I'm sorry, there's a lot of I-9 questions here, Laura. So now I'm going back
Okay.
to I-9s again. Lots of
Sure.
I-9s. And I know it's confusing. It is confusing. Can a bookkeeping company that does payroll for numerous clients be held responsible for their clients not having I-9s or not properly completing I-9s?
The simple answer is no. Can you go back after them for not doing what you contracted with them to do? Perhaps. But it is up to you under federal law as the employer to have I-9s and have either an agent of yours sign the I-9 that it was done completely, or you do it yourself. So you might be able to have have them indemnify you, but it's your responsibility as the employer to make sure the I-9s are done.
So this is a company, current employees, a Form I-9 was completed and then E-Verify was started. Should the company retain the Form I-9s that were completed, or more than 5 years have passed now? Or can the old Form I-9s be destroyed?
So E-Verify and I-9 forms run in parallel. If you use E-Verify, it's an add-on to the I-9. So you don't automatically stop using I-9 forms. You still have to do I-9 forms. E-Verify is an extra step you do after you finish the I-9. But if you start E-Verify now, and the company has been doing I-9s for 10 years, you don't go back and run E-Verify on your old I-9. You only go use the E-Verify system on a going forward basis. And as I said during the presentation, if you have old I-9 forms where the individual is no longer employed, there is a formula. It's either 1 year, 3 years after the date the individual is terminated. You can start destroying, shredding your old I-9s. But you don't have to go back and run E-Verify on them, on the old ones. And then you only use E-Verify on new employees. And then you should run the formula on getting rid of old I-9s when people are no longer in your employ.
Great. And you just answered a question that literally just popped up too. When employers register with E-Verify, can they just start using E-Verify with the new employees, or do we need to go back and run existing employees through E-Verify? And I think you just answered that and said, no, it's going forward with new employees.
That's exactly.
Okay. So speaking of new employees or employees who come and go, we have employees that come and go. It's a contractor. Um, do we need to redo the Form I-9 each time they come back to us, which could be seasonal or annually?
Mhm. So that's a good question. If they truly are an independent contractor, if they're 1099 or they're a vendor, you don't want to do an I-9 for them. If they were an employee and then they left and they come back within a year, you could use the old I-9 and just do the re-verification box on it. I find it's easier just to do a new I-9 every time the person comes back. But you are allowed to use an old one within a year.
Okay, thank you. And another question then, and you also just answered this, but actually we have two on this too. Just confirmation again that the Form I-9 is completed for employees, not contractors, subcontractors, as you put it, 1099. So it's individuals who you are issuing a W-2 for who are on your payroll, not
Right.
contractors.
But just keep in mind, and a lot of small businesses use 1099s, use contractors. But if the reason you're using a 1099 is because the person's not legal, that's not really kosher, right? We really
Right.
we should not be doing that. They should be an employee. They should be doing an I-9. And if ICE were to say, let me see a list of your 1099s and they're all illegal, and the reason why you hired them is because you knew you couldn't complete an I-9, then you're going to stand in this. You're going to be assessed penalties for knowingly hiring undocumented workers.
Right. So this is somewhat related to that, or I would say maybe the flip side, if you will. Can I use E-Verify for a client's workers, even though I'm not involved in hiring or completing the Form I-9?
No, no. You have to execute a memorandum of understanding with the Department of Homeland Security, and that memorandum details who you're allowed to E-Verify. So if you could get yourself in trouble for violating that memorandum of understanding, but you could also be held responsible for your vendor's employees if you use that vendor for other work. So no, you should not use E-Verify.
Okay, if you have an employee, this is a business who uses E-Verify but suspects false docs are being presented and approved by E-Verify. What grounds do I have to prove the documents are false, if
So
any?
is this somebody who's gonna work as an employee?
Yes, as an employee. As an
Mm.
employee. Yep. Ran them through E-Verify and it checked out, but the employer suspects the documents presented were false.
So again, we are the reasonable person standard. We are not required to look under documents. Now, if they presented a driver's license, I'm in Maryland, I live in Maryland, so I'm going to say presented a Maryland driver's license, and the driver's license says it's Jane Smith, and she's a 25-year-old woman, and the employee is a 45-year-old man, then perhaps that a reasonable person would say those are not accurate documents, even though they're going to clear E-Verify. That particular Jane Smith's driver's license and social will clear E-Verify. We shouldn't have let a 45-year-old man use a 26-year-old woman's documents. So if it's that blatant, then you should say, you need to give me other documents. This does not relate to you. But otherwise, if it looks reasonable, the person's presenting a green card, and the green card is evidence of work authorization and identity, and the picture looks like the individual, then you really should you really should take it, and it should clear E-Verify. It does happen that sometimes you'll get a call saying it looks like the Social Security number that this employee of yours is using is also a Social Security number for somebody who's in a nursing home or somebody who's passed away. At that point, we may have to reopen our I-9 and say, okay, you've presented me with a document of work authorization, the social, that is not valid. Do you have any other document? And if they don't have any other documents, then you would have to let them go. But yeah, you get on a slippery slope when you start trying to be the document police. Just be the reasonable person.
There's several questions about E-Verify, and I am happy to share. There's several, and I don't, maybe your firm has compiled this too, but I know several payroll companies have good charts that show which states require E-Verify and sort of the thresholds and those sort of things. If your firm has something, Laura, I'm happy to share that too, but I will include that in the follow-up email because there are several questions about that too. And as I said, I know some of the payroll companies have good maps that you can click on.
Exactly. Some states do require it, especially if you are either a state contractor or a federal contractor. Some states just require it of all their employees. We have a map that's out there. It gets a little dicey with the larger companies because some companies don't want to use it, but they'll use it in states which they are required to use it in. I just think it's a good practice to use E-Verify because you get into trying to split hairs on, well, am I doing federal contracting? Am I doing state contracting? Am I in Georgia? Am I really working from Tennessee? So there are state requirements, but again, I think the best practice is to use it for all offices.
Yeah. So good practice, but as of right now, not required nationwide, right? Nationally. Any, and this actually was a question too, your thoughts, if you know, and I know, I don't think you're a lobbyist and I'm not a lobbyist, so we don't have a stake in this necessarily, but do you think there is a possibility at some point in the future there would be a federal national requirement?
Yes, and actually, Elizabeth, I am a lobbyist.
Oh, you are? Okay, I'm sorry.
I do. I've worked on comprehensive
Yeah.
immigration reform and other immigration reform efforts for a long time, but we have worked with Jim Jordan's staff and Republicans on the House Judiciary um, to help and reassure them that we support a nationwide E-Verify effort. And, you know, obviously we as employers don't really want to have to be in this position where we have to check people's identity and work authorization. But if we are, we would like a foolproof system that gives us protection from liability. So I think it has been baked into a lot of the legislation that has been proposed. It will be proposed again. I think one of the big organizations that has pushed back on national E-Verify are the agricultural organizations because farm workers, I think the percentage is about 80% are undocumented. And until we can figure out a way to fix their worker shortages, there's been a big pushback there. But I do think that we will, during the second Trump administration, see nationwide E-Verify be implemented.
I'm going to try to roll together several questions, and we've got a lot that have come in the chat box on the retention of Form I-9s, and I don't know if you're comfortable, again, summarizing sort of the retention for people who have left, current employees, and when they've left, how long you retain them then. And then related to that too is somebody, this is a really great question too, who is looking to transfer to digital record keeping. So they've got some in paper binders, you know, from existing employees, but now going forward, they're going to transition to digital.
Yes, and electronic storage of I-9s is becoming more and more popular. And indeed, there are actually agents out there that will help you do the I-9, and they can be the agent for E-Verify. So if you want to, you can take that off your plate completely. And digital storage is fine. I have found when we are doing actions with immigration with ICE and they ask for copies of them, we try to take all the digital I-9 forms and records and send them over to them. They still seem to be a bit backward, and I would say probably 9 times out of 10 they'll ask us to print out what's on the thumb drive and send it over to them. But yes, you are allowed to keep them electronically, and we try to send them over to immigration electronically sometimes, but sometimes they just want um, the actual I-9 form. But yes, it's permissible, and there are actually really good agents out there that will help you with I-9 compliance and with E-Verify. They can act as your agent for E-Verify. And then in terms of, getting rid of your documents um, after the individual has left, you can either do it, the formula is 3 years after the employee's first day of employment. This is after they're gone, or 1 year after their employment terminates. So the individual has to be gone. I mean, obviously, if the person is still working for you, you need to have an active I-9. But if they are gone, I would run that formula and get rid of old I-9s that you don't need to keep. And that way, if you ever have an audit, you would not need to turn over documents for people who are gone, who you can lawfully have, destroyed their I-9s. Okay, I'm looking to see if we have any other questions. Elizabeth,
Yeah, I'm sorry. Yeah, do they have ICE during an audit, or ICE agents come in? Do I provide them with copies of the I-9s, or are they allowed to take the originals?
so again, you want to push them back if it's an audit, and then get them together. Usually they ask for the originals. We try to push back and see if they'll take copies, but we certainly want to, if they do require that you send over the originals, then you want to make sure you have really good copies of everything that you're sending to them. Again, this is why you need to negotiate some time to get everything together to comply, and don't just turn everything over on the day that they come in.
Okay. And several are asking about how to find counsel, good immigration counsel, including one participant who says they can't get any immigration attorneys to return their phone calls. So, do you? uh, and there is
Yes.
one individual that's asking if your firm is available to and taking on new
We
clients.
we do I-9 audit. We've got people in California and Texas and Florida, New York. Obviously, we're here in Washington, D.C. The American Immigration Lawyers Association has a really good um, directory, and it's based on where you're located. So you can look at aila.org. I'm also happy to make references to local attorneys, but we do these pretty routinely. You do want somebody who's familiar with I-9 audit. There are immigration lawyers that do nothing but deportation or asylum. So you want to make sure it's somebody who does have um, I-9 experience and compliance experience. But American Immigration Lawyers Association, we have teams that are working on I-9s all the time. We've done nationwide audits, so we're happy to help too.
Okay, and your contact information, I believe, was on the slide deck too.
Yes.
But if anybody needs it, reach out to me too. And I just dropped the link for the aila.org. That is a great resource, Laura, and I have shared that with members before too, because it is nice to be able to find an attorney in your area too. If you want sort of an in-person consultation, that can be very helpful if it's a visa issue or something that's going to be more involved. That's
Exactly. You can actually look in their membership directory too, under I-9s or business immigration or removal proceedings, and that.
okay. And more coming in. Another question too about a payroll company being held liable. And I know you answered this already, but it's actually come in 2 more times. And
Mhm.
if you are pretty certain that your clients are hiring illegal immigrants. So these are probably accountants or small payroll companies that are doing work for small businesses.
Yeah. So yeah, you're probably seeing social security numbers that don't make sense, or no social security number, or something like that. And so that does come up a fair amount. I think as a payroll company, it's not it's not your responsibility. I mean, you're not the one doing the I-9s. You can say something looks fishy here because this person's giving me an ITIN and not a social security number. And I'm not quite sure, whether you've done your work, your paperwork, but unless you own part of the company, I don't think you could be held liable for the owner of the company's failure to complete their I-9s. That's not your responsibility.
Okay. If you have time, I know we're up on the hour here, but question. This is actually a very good question too. I have a small business, 5 employees. What chances do I have of an audit? And I had a question come in earlier too, just sort of asking about, who are you seeing being audited? Are there sort of red flags or triggers, certain industries that are more prone to be audited or subject to a raid?
Yeah, I mean, right now, what's driving ICE is, as I said at the top, outstanding orders of deportation, criminal aliens, and tips, honestly. So if somebody calls in a credible tip and says, hey, listen, I think even if it's a small business, I think that business, this just happened here in Fairfax last week, I think that Indian business has illegal aliens working in the kitchen. ICE went in and they had probable cause because they had the name, and they actually raided the kitchen and took people out of the kitchen. So if you have somebody who's disgruntled and you're on your staff who might make that call, that could cause Immigration Customs Enforcement to do some digging and figure out whether you've got undocumented folk there. Generally, smaller businesses are not the target. The larger businesses, we've seen construction sites, home builders, franchises, fast food chain franchises, some senior living facilities with their kitchen staff. But yeah, generally it's not, they're not small businesses unless there's a tip, somebody calling in something where they think that you're doing something illegal.
Okay. Thank you very much. I think we've taken care of the questions in the chat box here. Is there anything you want to say before closing out, Laura? And thank you so much. This was so helpful. And I really want to thank you for taking over half an hour to answer questions, because I think that even though some of them were, repetitive, I think there was still, a lot of, confusion, particularly over the I-9s. So this was so helpful.
No, everybody just needs to be kind of vigilant and make sure that they're doing what they need to do to comply with their immigration requirements. This is going to play out as more and more people are destabilized. This is the Trump administration's kind of goal, is to remove people who are in some of these statuses that they don't feel are warranted anymore, humanitarian parole and temporary protected status, and some of the folks in the asylum queue. So we will have some more instability. Again, the target is bad actor employers and the illegal immigrants who are here, who are criminals and who have been already deported and who are in some of these destabilized statuses. But we're around. I know NFIB is vigilant and watching out for you guys, and you could always call them or call me if you have somebody come visit your site.
Thank you so much, Laura. And I'll turn it back over to you, Casey, to close it out.
Thank you, Beth, and thank you, Laura, for joining us, and thank all of you for attending today. That concludes our program. Visit nfib.com/webinars for all of our webinars on demand. My name is Casey for NFIB. Have a great day.
Thanks, everybody. Bye.
Thank you so much, Laura.